Now.
Okay, tonight we have Michael Nerheim, State's Attorney from 2012 to 2020, to talk to us about sentencing laws and procedures, police licensing, and funding. Mike began his legal career in 1999 as an assistant state's attorney and has experience working in all criminal divisions of Lake County State's Attorney's Office. He has overseen and was responsible for the operation of one of the largest state's attorney's offices in Illinois with a staff of 140 and a budget of over 15 million. He earned his Juris Doctor at Cum Laude from John Marshall Law School in Chicago. He frequently lectures nationally on a variety of social justice issues. And he's able to do this because of the many programs that he has sponsored and run here in Lake County. He started the Way Out program, which is for addiction, and local police stations take part in it, and a person who has decided to give up drugs or alcohol can go to the police station, turn their stuff in, and they don't get arrested, and they get taken to whatever they find an opening in rehab and take them to it. And it's been very successful, and it was kind of during COVID slowed down, but I think he can tell you, but I think they're operating again. And they have a children's advocacy center connected to the state's attorney's office. And now I can't even remember everything. So we're happy to have him and to hear him talk because he is very experienced and knowledgeable. So here's Mike. And if people have questions, you can put them in the chat. And at the end of his presentation, we will ask questions. Thank you.
Okay. Well, thank you, Linda. Thank you, Rosemary. My screen went blank while you were talking, so I could hear you, but I don't know if you could see me.
No.
But so hopefully that doesn't happen again. So what I thought I'd do is sort of go through some of these questions and kind of give you my thought process on some of these issues. And as Linda and I, when we talked a few weeks ago about this, on each question, I could probably talk for an hour. So I promise I'm not going to do that tonight. I'm going to kind of try to skim over these and give just some general ideas and my thoughts on that. And again, that's going to be based on my experience as both a prosecutor and a defense attorney. So I've been on both sides of the law. And I think, having that perspective is important, especially as it relates to these issues. And then police licensure is another topic that I certainly think the league will be interested in, and there will be some legislation that will be proposed here in the next session that, I'm sure you'd want to take a position on. So with that, I'll just kind of jump into, I guess, 11A in terms of the strict enforcement of penalties for crimes with regard to handguns or assault weapons. And currently Illinois law, and I'll speak to Illinois law and not federal law, and although my focus has traditionally been in Lake County, a lot of these are pretty, these are statewide issues. So there may be some difference in how they are practiced depending on the county, but the laws should all be the same because these are state laws. So currently there are laws in Illinois that do mandate a higher sentencing structure if a firearm is used. There are other specific laws that relate to handguns or assault weapons, but really Illinois law kind of focuses on a firearm. There are enhancements that are mandatory currently. If, for example, a murder is committed with a firearm, there are mandatory enhancements that go along with that. There's a crime called armed violence, which is basically committing a felony well armed with a firearm is its own serious offense. So current law does have enhanced penalties because of somebody using a firearm in the commission of those crimes. And I think, one of the reasons for that is our legislature has recognized how dangerous firearms can be. And it's not to say that murders can't be committed with other types of weapons. And certainly even in Lake County, we've had murders committed with automobiles. We've had murders committed with knives. We've had murders, strangulation murders that are committed with somebody's hands. So a murder, you're still taking somebody's life. And, certainly those are very, very serious crimes. Our legislature has recognized that firearms pose a significant threat to our society when used in the commission of crimes. And that's why they have, our legislature has added those enhancements. Now, I read through some of the pros and cons about kind of getting away from that. And there's some discussion about whether the data supports, whether these enhancements act as a deterrent. And I think, certainly there's studies that have shown that sometimes they don't. But I think what you have to, recognize is when somebody is being sentenced for a crime, one of the hopes is that sentence will deter others from committing that same offense. And that is one of the factors that's considered when somebody's being sentenced. It's not the only factor, though. It is an important factor, but that's not the only reason why people are sentenced. There's other factors, and it's not about retribution. Courts should be looking at rehabilitation. Courts should be looking at trying to provide an overall sense of justice for a particular case, and that's going to depend on the facts and circumstances, not only of that case, but of that particular defendant. And obviously, there's kind of a bright line that we can draw between violent and nonviolent offenses, but sometimes that line's not even as clear as people would like it to be. But for, I think it's basic psychology for something, and all of us that are parents know that for some sort of punishment to work as a deterrent, for it to be effective, it has to be swift and it has to be certain. And our criminal justice system is neither. So when we look at whether certain sentences actually serve as a deterrent, I think we have to recognize that these sentences, although they are set forth by statute, they're certainly not imposed swiftly. And I'm not advocating that they should be. I think we need to take our time in our system to make sure that somebody receives a fair trial and the process is fair. And sometimes that takes time, especially the more serious the offense, because these are complicated cases. But the application of that law is almost never swift in our system, and it's not certain, because this is where, even though these laws are the same on the books in every other county in Illinois, there's 102 counties in our state, and somebody committing an offense with a handgun, that person is going to probably be prosecuted differently depending on where that crime's committed. So if something happens in Cook County versus Sangamon County versus Lake County, all those different state's attorney's offices, all those different counties have different theories on how these crimes should be prosecuted. Prosecutors have a lot of discretion in how they're applying these laws. So there's not very much consistency even within one state in terms of how these laws are enforced. So there's not certainty. Even though we have these mandatory enhancements, people, would-be criminals, aren't necessarily thinking that if they go out and commit this crime that they are for sure going to get caught and that they are for sure going to have this penalty. They're just not. So I think, if we really want to think about whether crimes or sentences are acting as a deterrent, we have to think about those things, because they don't always do that. But again, that doesn't mean that we shouldn't impose some of these sentences. And I think of other crimes like, and I know that's not the question here, but crimes like predatory criminal sexual assault, for example, or crimes involving the abuse of children. Studies have shown in those crimes carry among the highest sentences that we impose in our legal system. And studies show that those sentences don't act as a deterrent. The prospect of receiving a high sentence is not going to stop somebody from preying on a child. There's so many other factors that go into that, but that doesn't mean that if somebody does commit that crime and they're caught and found guilty, that they shouldn't be sentenced, because there is the argument that the punishment should fit the crime. And here, and again, it's easy when we're talking about some of the most serious offenses, and it's also easy when we're talking about kind of low-level nonviolent crimes when we talk about all these other areas where we can utilize some of our diversion practices. So I'll move on because again, I'm already probably going
Mike,
too long.
not to interrupt, but someone asked, this might be a good time to define enhancements.
So so our laws in Illinois are broken up into categories. So we have felonies and misdemeanors are by definition crimes that you can receive up to a year in jail for. So they're by nature going to be less serious offenses, battery, retail theft, things like that. Although those also have felony versions if there's aggravated battery or enhanced retail theft based on priors or somebody's criminal history. But then when you get into felonies, they're classified, they start as class 4, and then they go 3, 2, 1, and X. In descending order. So 4 is the least serious felony. You could go to prison for between 1 to 3 years. And X is murder and some other more serious felonies, and you can go to prison for up to 30 years. And so each one of those, class 4, class 3, class 2, class 1, and class X, each has its own normal sentencing range. So as I said, class 4 is 1 to 3 years. Class X is 6 to 30 years. But there's also enhancing factors that come into play where a quote unquote normal class X could be enhanced where that normal 6 to 30 range is increased. Some of those enhancements are, again, as we talk about here, using or possessing a firearm when committing those. There's also aggravating factors that can also increase the sentence. Some of those could include, if the victim is somebody that's elderly, or if the victim is a child, if the victim is a police officer or a paramedic. I mean, there's a whole list of these aggravating factors that are in our sentencing structure. But when I talk about enhancements, I'm talking about specific to this question, firearm enhancements, which take what would normally be a class 2 or a class 3 felony, that normal range, and it makes it higher. So I hope that answered the question. Did it?
Yes, I think so.
Okay. All right. So 11B, should evidence-based practices and best practices guide sentencing laws in prosecutorial decision-making? Absolutely. I think, and there thankfully has been a move towards this more recently in our system. And my personal opinion is, we need more of this, because I think judicial discretion is very important, and I think judges should have the discretion when imposing a sentence to consider a lot of factors and issue a sentence that they believe is just in that particular set of facts. But in order to do that effectively, you need good information. There's assessment tools out there, but there's also a move towards a more trauma-informed focus. So you're not only looking at the harm caused to the victim, which should of course be done, but you're also looking at the offender and perhaps trauma in their life and what caused their criminal behavior, which we find is most often a combination of mental illness or substance abuse issues, which is why we've really tried in our county to address a lot of these issues up front with some of our programs, our pre-arrest programs. We also have drug court, veterans court, mental health court. These programs all recognize that a lot of people that come into contact with our system have these underlying issues, and that's really, if you kind of peel back, that's what caused the behavior. So you're not just looking at, ideally, you're not just looking at the crime, but you're also looking at and trying to identify what caused that person to commit that crime, and how can we, best deal with that, because incarceration, and I'm not just saying this because I'm no longer a prosecutor. I've always believed this. Incarceration should be the last resort. Certainly there are offenses where people need to be incarcerated, the violent offenses, sex offenses, things like that. But the majority of these cases, people, incarceration should be a last resort. And the goal should be to rehabilitate that person and also bring some sense of justice to the victim and society. And there's practices now that are being employed in our juvenile court system in Lake County that hopefully will be brought into the adult system. You know, really kind of using this balanced and restorative justice approach where you're trying to get to, again, the root cause, address what caused the criminal behavior, and then try to bring resources to bear. And you can also do that with having input from a victim, because a lot of people, I think, feel that you know, those two concepts don't work well together, where you can't, in order to have a sense of justice for a victim, there has to be incarceration or there has to be a severe sentence. And that's almost never the case. And what we found is, you know, victims certainly need to be heard. And that's one of the biggest frustrations that we would hear from victims in our system, is they feel like they're never really heard. And victim offender mediation, for example, is a program that does kind of, it's a pure form of balanced and restorative justice. And what we found is when victims are able to be literally be heard, to sit in a controlled environment and tell the offender how what happened to them made them feel and how that impacted them, oftentimes what we found is once they've been able to do that, they were fine. They had their sense of justice. They didn't need their pound of flesh, so to speak, and they can move on. And it was important for the offender to hear that, because that helped in, you know, in their process in terms of you know, addressing whatever it was that caused them to commit that offense. Now, this doesn't work for every type of offense. You know, this probably wouldn't work in a murder case, or you know, some of the more serious offenses. But for some of the more nonviolent, you know, property type offenses, it works very well. And I think that can be certainly used in adult court. But there has been a shift towards a more trauma-informed approach in our sentencing. So, you know, so judges can make better, you know, better decisions with the information that they have. 11C, should sentencing take into consideration public health issues? Absolutely. And I think also there is a shift towards that in our system. You know, our criminal justice system is very slow to change, but in my career, I've seen these changes come about. You know, we talked up front about some of the specialty court programs, you know, these kind of broad public health issues. And I saw the con listed here that public health is sort of too broad of a term, but this is a term that's used very often in the criminal justice setting today. And I think it has to be part of any real reform. And I love how you've recognized that early education is a big part of this. When I was in the office, I was the co-chair of Illinois of a group called Fight Crime, Invest in Kids. And essentially what that group is a group, it's a national bipartisan organization, and it is made up of police chiefs, prosecutors, sheriffs. There's a sister agency that's admirals and generals that are retired. But the whole point of what we lobbied for was recognizing that providing quality early childhood education for everybody, and also quality after school programming for teenagers significantly reduces the likelihood that those children are going to grow up and commit criminal behavior. And there's study after study that supports this. So as a state's attorney, which is literally the chief law enforcement officer for a county, combined with the sheriff and police chiefs, we would go to Springfield and Washington and lobby for funding for early childhood investments, recognizing that, you know, really, if we want to get to the root cause of preventing crime, we need to start at that birth to 3 range, which may sound a little silly up front, but again, there's plenty of data to suggest that to prove that this is accurate. So I'm glad that you're recognizing that when we talk about public health and prevention, that we need to go as far upstream as early childhood. And then certainly recognizing, and as I've said earlier, that the majority of people that penetrate into the system have substance abuse or mental health issues. And that's why it's imperative that communities have and use specialty courts. Lake County, we're very lucky. We were among the first in the state, but we have a drug court, veterans court, mental health court. Those are all sort of self-explanatory in terms of the type of behavior that they seek to address. Drug court, our drug court system in Lake County was and continues to be a prison diversion program, which is for high risk, high needs individuals. These are individuals that have been in and out of the criminal justice system most of their adult lives. They've been to prison multiple times and keep getting out and committing offenses and then getting rearrested and going back to prison. And then, the cycle keeps repeating. And what drug court recognized is, again, this is a public health issue. If somebody's addicted and suffering from that disease and they go to prison for 6 months and they're not addressing that, they're going to get out and you really haven't solved anything, because that person, they're not, they haven't addressed that addiction properly in prison. And then they're going to get out and they're going to go back to what they know. So what drug court seeks to do is break that chain. It's very intensive treatment. But it really, again, is a prison diversion. So rather than kind of keep sending people back and forth to prison, they get very intensive probation, but it's community-based, and there's peer support, recovery coaches. It's a great program, and it brings a lot of resources to bear on each individual defendant. And it works, but it's very labor intensive. Again, there's a lot of effort for each individual person, but again, it's bringing this kind of public health lens to the criminal justice field, recognizing that, if you were to somehow be able to snap your finger and take that addiction away from that person, they probably never would have been involved in the criminal justice system. So we need to recognize that and do everything we can do to help them address it. Mental health court is another great program that recognizes that a lot of people end up in the system because of mental illness. And what mental health court seeks to do is identify those people, get them resources, and then get them back on their feet. Ideally, though, we would be able to help people before they even came into the system, which is why we came up with the Way Out program, which helps people pre-arrest before they're ever even brought to the courthouse get access to care. So I think what's important is, we have to be able to look at this from, all across the spectrum, from both, going all the way back to early childhood, but then recognizing that, these public health issues are very intertwined with our criminal justice system. And almost every defendant that comes into our courthouse needs help in one of these areas. And I think we absolutely have to make this a priority. So I don't know if it's a good time to pause for questions, Linda, or should I just keep going?
You're kind of answering some of them.
Okay.
But why don't you just keep going, and then we'll see how many questions we have time for. Okay.
Collaboration between stakeholders with regard to sentencing outcomes. And there's talk about about our adversarial legal system. And, it's interesting when you compare the adult criminal justice system with the juvenile criminal justice system, they're very different. The goals are different. In the juvenile system, it is everybody, including the prosecutor, is looking at what's in the best interest of the minor, the person that is before the court. It's not an adversarial system per se. It's really everybody between the prosecutor, the defense attorney, the judge, probation. They're all supposed to be looking at what's in that person's best interest, and then whatever sentence comes out of that, that's the goal. Whereas our adult system is more adversarial, and that's where it gets a little bit tricky. And when we talk about some of these concepts like drug court and veterans court, mental health court, I think it gets a little bit nuanced in terms of the perceived role of the attorneys. And again, I've been both, and I know, your role as a prosecutor is pretty broad. You go into court and you're there to seek justice, and it's not just, you're not just there for the victim. You're not just there for the police, which a lot of people think, the prosecutors represent the police and the defense attorneys represent the defendant. The prosecutors really are supposed to be looking out for the greater good and everybody, including the defendant. The defense attorneys, they're taught that their job is to represent their client and to get that person the best outcome that they possibly can in that particular case. And that's where it gets a little bit And there's nothing wrong with that. I've done that as a practicing defense attorney. But if you let's think of drug court, for example. Drug court although it's a prison diversion program, it's a difficult program. I mean, you go to court once a week. The drug court team is telling you, where you can work and where you can live, and you have to, you have to be very invested in your recovery to be successful. And I can remember as a defense attorney, I would have a lot of clients that if I were offered either, you can go to prison for a year or you can take drug court, believe it or not, I would have a lot of my clients say I'd rather go to prison for a year, because they knew they would do the math with the sentencing credits and they knew they'd be home in 2 months and they'd be done, versus drug court, which is 3 years of very intensive, people kind of in your life. And if they weren't ready for that, it was hard. It was difficult to convince my clients that while, prison may be quote unquote easier, the better route for them in the long term would be drug court. Now, ultimately, it's going to be their decision. As the attorney, all you can do is make recommendations and tell your client what you think the best thing for them to do is. But ultimately, it's going to be their decision, and they're going to do what they want to do. But some attorneys feel like it's their job to sort of get their client off, get them the best, easiest deal they can, even if that might not be in their long-term best interest. So, and that's where our adversarial, the nature of our system, it gets a little tricky, because you're not always, whatever you come up with might not always be in the long-term best interest of not only the defendant, but society ultimately. So I don't know if that makes any sense, but that was something that would come up quite often, just in my practice. And I would see it as a prosecutor too, where we would, you'd see somebody that was struggling, that really needed that probation, that the treatment component, but oftentimes people would rather just take their time and be done with it, which is almost never the better way to go. Racial impact statements, should they inform any new criminal law or regulation? Absolutely. I think there's a comment towards the bottom in terms of cons, that laws should treat defendants equally, and ideally they should, but we know they don't. And I think certainly when laws are passed, it's important that our legislators look at the potential impact that those laws are going to have on particular communities. So I think that should be that should be considered when drafting legislation. But ideally, when enforcing laws, it shouldn't matter. But absolutely, in drafting legislation, our lawmakers should be looking at the potential impact that their decisions are going to have on different communities. And I think, when I think of some legislation historically, it's pretty clear that wasn't always taken into account. You can look, and I know you've recognized this, disparities in sentencing laws between crack and powder cocaine. The reason for that is a lot of those sentences, when they look at those studies, those are federal sentences, federal cases, and federal law is different than state law, where when it comes to drugs, for example, the purity of the drug is an element in federal law, and it's not necessarily an element in state law, and that kind of can cut both ways. So, and I'm getting a little bit into the weeds here, but for example, in federal court, somebody sentenced to possessing cocaine, the purity of that drug is going to be a factor. Whereas in Illinois, the way our laws are written, it's any substance containing any amount of a controlled substance. So theoretically, if you have a kilo of baby powder with a little bit of cocaine in it, and that tests positive for cocaine, you've got a kilo of cocaine, even though it may be 99.9% baby powder. And it may look like a kilo of cocaine, but if there's any amount of a controlled substance in it, you've got a kilo of cocaine. And our sentencing laws based on drugs are all based on the weight. So, a kilo is going to be sentenced much higher than somebody with 3 or 4 grams. But that's an important distinction. And I think also, back in the 80s, you think about how drugs have kind of come and gone through the years. Crack cocaine was a big issue in the 80s. It's really not around that much anymore, although cocaine has been making a comeback in our community. But today it's, well, I should say yesterday, it was heroin. And we saw our sentencing laws kind of structured around that, recognizing all the people that have died, the 60,000 Americans a year. But then today, when I say yesterday it was heroin, today is fentanyl. And our legislature is now looking at this drug fentanyl, which is 50 to 100 times more potent than heroin, and people are dying left and right. And now, even though there is a movement to decrease some of the minimum sentences related to other drugs, they're talking about increasing some of those as they relate to fentanyl. And I think the reason they're doing that certainly is they're recognizing the dangerous nature of this particular drug that is in front of us today. But what's it going to be tomorrow, and what's it going to be next year and 5 years from now? So, I think the legislature has to be a little bit more consistent, but also look at the impact that these laws that they pass have on different communities, because we know, looking at the 80s, that the travesty that was in terms of this different sentencing guidelines between crack and powder cocaine, and how that had a racial disparate impact on different communities because of essentially the same drug, just in a different form, being used by largely different communities. And then you're going to have a much more significant impact on communities of color, and that's just fundamentally not fair, especially when you're talking about basically the same drug, just in a different form. 11F, should legislation that reduces penalties for a crime also benefit those previously convicted and sentenced to for that crime? Here there's some tricky constitutional issues that come into play that need to be considered, and I understand kind of the rationale for looking at that. But again, setting aside constitutional issues, if somebody pled guilty to an offense, there were a lot of kind of factors that went into that disposition. And in our criminal justice system, I think it's over 98% of cases resolved by way of a negotiated plea of guilty. And it's a negotiation in that sense, that there's some give and take. And perhaps if somebody was sentenced to an offense 10 years ago, maybe they had two offenses or two cases, and in exchange for their plea, one of those was dismissed. Or maybe in exchange for their plea or testimony or some sort of give and take, they received a sentence, but again, they received the benefit because of some give and take. And also, with the other factor that's kind of left out in these discussions is the victim. And the victim or their family, if it's a murder case, the family of the victim, there was a lot of input that they provided in this sort of whatever the negotiated sentence was. But that was what everybody at that time kind of agreed upon based on everything that was in front of them then. And, I think it's important to consider that when you now 5 or 10 years later, if the law changes or to consider changing laws to then go back and reduce those sentences even further, I think you have to consider the fact that whatever benefit they got then, those cases that were dismissed, those counts that were dismissed, the victim's input. I mean, the victim and their family, and that's an important element. I mean, the victim, their input isn't going to always be the sole driving factor in an offer that a prosecutor is going to make, but prosecutors have to and should consider that input, and victims should be allowed to give that input. And if they sort of sign off on an agreement 10 years ago and then automatically that just gets changed 10 years later, I think we certainly need to consider their feelings as well. And that's why, because of both the constitutional issues and kind of the bargaining and benefit of the bargain issues, that's something that I would encourage people to think about when looking at retroactively changing some of these cases, especially considering, like I said, almost all of them were negotiated plea agreements. Moving on, I'm trying to go quick because again, each one of these is there's a lot to talk about here. Felony murder. Felony murder is a crime that is not on the books in every state. It's a somewhat controversial offense. We have it here in Illinois, and essentially the way it works is if a group of people commit a forcible felony and somebody dies during the commission of that felony, everybody that committed that felony is responsible for that murder. In the rationale for that is our legislature and our courts have recognized that when people get together in a group and they commit a forcible felony, and I think it's important to pause and talk about how felony murder only applies to forcible felonies, which by nature are the more serious violent felonies. It's not any felony, it's not any offense, it's forcible felonies. And the law has recognized that if a group of people get together and commit a forcible felony, that the chances that somebody's going to get hurt or killed skyrocket. And therefore you should know that. And if somebody does die, then you're going to be on the hook for it. That's the rationale behind felony murder. And that's whether, I know some people agree with that and some people don't, but that's the rationale behind why we have that. Now, I know there's been controversial cases. There's controversial cases that I've dealt with as state's attorney that are still controversial. So believe me, I get it. And I think, certainly some of the discussions that have come more recently with regard to felony murder, there's talk about abolishing it altogether. There's also talk about abolishing it as it relates to juvenile offenses, which, I think that's certainly a discussion worth having, especially considering what we've come to learn about brain development and accountability. But I think also, speaking of accountability, the felony murder doctrine kind of fits into our theory of accountability in our system. So, I know in some of the examples that I've seen in the papers that you've supplied, you talk about the getaway driver. If the getaway driver, let's say a group of people go rob a bank, and you have the person that's sitting in the car and then the people that go in and rob the bank and then they come out. Our laws, our theory of accountability, setting aside felony murder, says that getaway driver, even though they never got out of the car and never even went into the bank, they are guilty of burglary. They're committed of bank robbery, rather, because they helped in the commission of that offense. So that's, that theory of accountability is pretty well established in our legal system, and that also kind of funnels into the felony murder doctrine. But discussing whether, because again, if you're thinking about the whole reason why we have this is this recognition that if a group of people commit a forcible felony, they should know that there's a much higher likelihood that somebody's going to get hurt. And again, as it relates to juveniles with brain development, there's a very good argument to make that perhaps they're not able to think that way. They're not able to really rationalize that thought process. So maybe felony murder should not apply to juveniles. There's also discussion of having it not apply if a co-offender is killed. So essentially what happens with felony murder is if, let's go back to the bank robbery scenario. If people go in and there's a shootout in the bank and the security guard in the bank is, pulls out his gun to try to stop the robbers and shoots somebody and ends up killing an innocent person that's just somebody in the bank, a customer, that murder, that person's death is not going to be necessarily on the security guard. It's going to be on the robbers, because again, the theory is that the reason why that security guard pulled their gun to stop the robbers is because they robbed the bank. So the person dying, that murder should be on them. Now, what happens if the security guard pulls out his gun and shoots and kills one of the robbers? And, let's say there's three and the security guard kills one of them and two of them get away. Well, felony murder currently would apply, and the two other robbers would be responsible for murder for their accomplice being killed by the security guard. So I've read some articles that have suggested in that scenario where a co-defendant is killed, that felony murder would not apply. So I think the point of what I'm trying to say is really trying to kind of talk about the purpose behind felony murder, but also, some of the different alternatives that have been proposed beyond just simply abolishing it altogether. I think there's certainly areas to look at, and in my opinion, one of the easiest ones would be to make it not applicable to juvenile cases. Funding, funding is I know it's a big part of this discussion. Police funding, I know there's been a push to defund the police and things like that. And I think, certainly my opinion is that police need more funding, if anything, because when we talk about, a lot of what we hope police officers are doing and what we hope police officers are being trained on, really a lot of that has to do with funding. I mean, I'll give you the example of crisis intervention training, and that's the type of training that that police officers should all have, which gives them some basic understanding of mental illness and de-escalation techniques. And the goal of that training is when police officers encounter somebody on the street that's in a mental health crisis, to recognize it for what it is and then de-escalate the situation. And hopefully the next step would be to be able to divert that person from the criminal justice system. Because historically officers didn't have that training. They might perceive that as a threat, and they're not de-escalating, and that situation can spiral into a violent encounter, or at best it spirals to an arrest where that person is taken to the jail, really unnecessarily, because this is somebody in mental health distress and not a criminal, so to speak. So what CIT training is supposed to do is, again, give those officers the tools that they need to identify that, de-escalate, and then get those people to help. And that's where programs like the A Way Out in the crisis center that's being worked on come into play too, as the next step. But these things all require funding. The other area that I've seen promise in Lake County, and this is being employed in other police departments around the state, is police departments employing full-time social workers, not to supplement or not to replace police officers, but to supplement them. And I know there's a handful of communities in our county that, as I said, have had great success with this. So when police are responding to a domestic violence call or a situation like that, now they can bring a social worker with them to help working on that dynamic literally from the scene. These social workers have also been used to help de-escalate situations where the police have been called, and to help really divert people away from the system and into treatment. So, that's another area where I think if more departments had funding to bring these social workers on to supplement their force, I think a lot more good could be done, because, when you think about police department budgets, a lot of the majority, the percentage of the funds that go to that department go to salaries and benefits for police officers. So any significant reduction in a police department's budget has to include a reduction of the number of police officers on a particular department. And currently the reality is most police departments are understaffed as is. So any significant reduction in a budget of a police department is going to bring them further understaffed. So, I think, when we talk about having officers better trained, when we talk about having officers, bring this trauma-informed lens to their work, that's going to require funding to get that training up to par. So I just think, that's certainly something that we have to consider, and especially as this notion of defunding or reducing budgets has become popular to talk about. I think there could be some unintended consequences to that, although I understand the point. Let me shift to licensing, because it's a sort of a good segue here, and I know I'm running a little bit long here. So this is something where you can expect to see some draft legislation here pretty soon, and regarding this whole concept of police licensure. And I'll back up and sort of talk about why this came about. And this all comes into the discussion of police accountability. So currently, the minimum requirement to be a police officer in many departments is a high school education, is a high school degree. And, you know, you have a lot of police officers that are young. You know, they get on these departments and they go through their basic training. They have a field training program. And then, you know, oftentimes they, sometimes, well, not oftentimes, but sometimes they will sort of hop around from different departments depending on where jobs are available. So they may start in one department, get some experience, and then move on to different departments. And I say that to say that simply a police officer moving from one department to another is not always a red flag. It can be, but it's not always for a bad reason. Sometimes that's sort of the normal career path for police officers. But what we've seen is, if you have a police officer that commits some sort of misconduct, depending on the severity of the misconduct. So if it's a criminal offense, so if a police officer commits a domestic battery, that police officer is going to be arrested, they're going to be charged, they're going to be prosecuted, and they're going to lose their job. There's certain crimes currently that if a police officer is convicted of those offenses, they automatically are not able to be police officers. There's automatic disqualification. So those are kind of easy. Those are the clear cases where misconduct occurs, and if it's a violation of the law, they're disciplined internally, they're fired, but they're also prosecuted and they're out of the profession. Then there's cases that are a little bit less clear cut, where a police officer may engage in some sort of misconduct that doesn't necessarily rise to a criminal offense, but it's serious enough to where it could impact their job. And what happens sometimes is once that person is sort of found out by the administration and that police department, the process that particular chief would have to go through to terminate that officer is pretty involved. So what happens, unfortunately, quite often in our system is that officer, rather than go through the potential of having been fired, will simply quit and go to work at another police department. That particular chief is happy to let that person go because they didn't have to then go through that whole process, the termination process that can be very involved and very expensive. So they're sort of out of that department's hands. But the problem is that officer then goes to another department and becomes a problem at a different department, and nobody ever really knows about it because it doesn't rise above and doesn't come out of that police department. So you have some of these quote unquote bad officers that are sort of bouncing around between departments. And again, this is conduct that is serious enough that they should not be police officers, but does not necessarily rise to the level of a criminal offense. So what licensing would do is it would require police officers to be licensed. And in our state, to be a hairdresser, to be a nurse, to be a lawyer, to be a doctor, all sorts of our professions require a state license. And this would require a license, and it would also, more importantly, add some oversight, and it would add an independent, neutral body that would oversee the licensing and would also oversee discipline. So the closest parallel to this is what attorneys have, which is the ARDC. And as an attorney, you are licensed to practice law. You have a code of conduct that you're supposed to abide by, which is independent of the criminal code of conduct. And if you violate that code of conduct, you can lose your law license, and you have to answer to the ARDC, which is a completely separate body. There is, non-lawyer involvement in that. There's a whole process, discipline process that attorneys have to go through. There's the ability for citizens to make a complaint against an attorney alleging a violation of the ethical rules, and there's an investigation that's conducted, and attorneys have to answer to that. And this happens all the time throughout our state. And I think certainly having a similar mechanism in place for police officers would help address the situation I described earlier, because now, and there's also, which is very important, there's a mandatory reporting requirement for attorneys. So if I, as an attorney, know that one of my fellow attorneys did something unethical in violation of our code, I have to make a report. I don't have any option. And if I don't, I could be facing discipline myself. So, and it doesn't matter. I mean, it could be your best friend, but if you are aware of unethical conduct, you have to make that report. And that would also apply. There would be a similar mechanism in this, crafted into this legislation, which would have a mandatory reporting requirement. So now if somebody committed some sort of misconduct, that would have to be reported to this agency that would conduct their investigation, even if the particular chief or sheriff didn't want to look at it or was just fine to let the person quit and go somewhere else, they would still have to make the report. So you'd have this independent body that would investigate the situation. And there would also be the ability for regular citizens to make a report directly to this licensing body if they wanted to bypass the police department. If they didn't feel like their report was going to be taken seriously at that level, for example, they could go right to this body. And again, what it would do, it would add another layer of accountability. Because right now, as a lawyer, if you commit an offense, or if you violate, let's say you violate an ethical rule, or you violate the code of conduct, and that conduct is also criminal, or perhaps even there may be civil ramifications, you are subject to discipline from all of those areas. So let's say, for example, an assistant state's attorney, has too many drinks and gets behind the wheel and drives home from work and gets in an accident and hurts somebody. That person is subject to discipline from a variety of different independent areas. Number one, there's civil liability for the person that they hit. Number two, there's criminal liability for the DUI. Number three, they're going to have to face their employer. And then number four, regardless of what happens on any of those first three, they're going to be subject to discipline from the ARDC. Now, discipline doesn't always include a revocation of licensing, but that would be sort of the most extreme punishment that this body could inflict, which would be, again, revocation. But there could also be, with attorneys, there's censures, there's suspensions, or if something is substance abuse related, there may be a requirement for treatment or something like that. But again, the idea would be this independent other agency to which these officers would be accountable. So we're coming up on an hour. I've been talking a lot, and I want to make sure I get to questions. But I did want to touch on that because that's something that has been crafted over the past several months. And there's been some legislative hearings on it, and legislation is being drafted. And I think this is something that the league should look at, certainly moving forward. There's been a lot of input from police. And personally, I've talked to a lot of police chiefs about this concept in Lake County, and everybody that I've talked to is very supportive of the idea. Even the rank and file police officers have been supportive of the idea. Their goal is they just want to make sure that whatever system is agreed upon is fair and that there's due process for them. But it's been comforting as I've talked to a lot of these officers and chiefs that this theme that they don't want these bad officers out there either. And if this would help eliminate and identify some of that, they're supportive of it. So I think it's going to happen. It's just a matter of how that legislation gets what it ultimately looks like.
Well, speaking to that,
I'll butt in a little bit first because some people might be leaving. And I don't know if we told you this, Mike, this recording is going to be loaded on our YouTube channel. So as we get to the questions, if some of you need to leave, you can tell your league members that this will be uploaded in a few days onto YouTube. And I'll send an email to everyone who registered for this program, and we'll send it to Janet Kitlaus with a list of all our YouTubes. So Martha and Linda, can you take turns asking the questions?
Sure. Well, I'm going to ask this one from Cheryl first because he was just talking about it. She wondered if there's any jurisdictions that currently have police licensing.
There are some states, Missouri, I know is one of them, and there's a handful of other states around the country. It's not, there's only a few, but Illinois would not be the first.
Okay. And then,
Well, and also from Cheryl, she'd like to know how you can calculate how much a police department is underfunded by. What is it based on? Is it based on population, crime rate, anything else?
So I think, you know, the easiest thing to look at is they each have a sort of based on population. There's a kind of an trying to think of the right word. There's like a average number of officers that they have on duty at a particular time. And I know a lot of those departments are down based on whatever that number is, their staffing needs. But again, that's gonna be different depending on the jurisdiction. And there's some other factors that come into play here too. And I think, you know, some of this has to do with the current environment that we're in right now. I mean, I talk to a lot of chiefs of police and they have a really hard time recruiting. There's a lot of people right now that, you know, it's hard to find young people that want to go be police officers. And that's something that has to be fixed as well. But yeah, so they have, you know, they have set kind of staffing guidelines per department that are many of which are kind of under that guideline right now.
Thank you. Linda, do you have another one?
you spoke to this a lot, but someone asked, what juvenile justice reforms do you advocate?
Well, I think, you know, definitely increasing the amount of programs like victim offender mediation. You know, I think certainly looking at accountability and, you know, considering brain development as we apply these theories of accountability to juveniles. You know, again, as I talked about felony murder, perhaps making that not applicable to juvenile offenses because of brain development and accountability theories. But really, you know, and this is happening, so this isn't new, but the more we can employ restorative justice principles in our juvenile justice system, the better. And again, this is not new. This is happening. It's happening across the state. But I've seen it work. And you know, I'll get back to balanced or victim offender mediation, which we have in Lake County. You know, that's a wonderful program. But you know, this is where the rubber meets the road when it comes to budget talks, because you know, we're in some pretty dire situations here in our county and across the state because of COVID. And I know, you know, one of the things that was sacrificed in our budget was victim offender mediation was reduced. So, you know, and I understand that the realities of budgets in the economic climate, but you know, these programs work, and we can't be afraid to invest in them. So, you know, I think more secure funding for these programs would be important, because you know, these programs aren't in place in every county in Illinois because they don't all have the funding and the resources to do it. And it really shouldn't, you know, justice shouldn't mean one thing in one county and something else in another.
Well, you were just talking about that, and one of the questions was if we had any hard data about the effectiveness of restorative justice interventions, you know, as opposed to traditional arrest and jail.
Yeah, I don't have any on the top of my head, but I think if
It's out there.
any bit of research on this, there's plenty of articles that have been published about these principles, and they work. So there's a lot of information out there.
Someone asked that many people argue that the real problem is that we are too lenient on criminals. Can you give us some talking points, like an elevator pitch that would include facts and data that we could use to dispute that?
I think, you know, drug court is another great example of why that's certainly not always true. And I think, you know, when you think about our drug court program, everybody that goes through our drug court program would otherwise have gone to prison. And yet, you know, you see a much lower recidivism rate. You see people that get into long-term recovery, that are out talking into the community, helping talk to kids about staying away from drugs and things like that. And there's data, but I like to talk about stories. And there's a person that I work with in our drug court program that had been in and out of prison for his adult life. He got drug court. He's been in recovery for a long time now. He worked the program. He did very well. He then went to college, and he spends a lot of his time going around and doing peer support for other people that struggle with substance abuse. And when I talk about that, and that's a real person, and when I talk about that person to somebody that's sort of a tough on crime, lock everybody up person, and you tell that story and you say, where would you rather have that? As a society, where are we better off, with that person in college or in prison? And even those people will say, well, yeah, okay, well, that guy, he's better off in college. But the point is that there's a lot of people out there that, again, the whole concept is the vast majority of people that come into contact with our system struggle with mental illness or substance abuse, or both. And putting them in prison isn't addressing either of those. And arguably it's making it worse. And if you put almost everybody that we put into prison as a society is going to come out at some point, and they're going to be part of our society again. So how are we helping ourselves by sort of making that worse? Wouldn't we be better off by trying to treat that and trying to help that person in the long term? Because if you want to look at it selfishly, certainly obviously it's helping that person, but selfishly it's helping all of us, because they're much more likely to be productive members of society, and they're not going to be victimizing people. So there's plenty of situations like that support that concept. Now, there's other offenses where, when we talk about crimes like murder and sexual assault and things like that, it's a different story. But, again, the vast majority of these folks, these are not bad people. These are not evil people. These are people struggling with what is essentially a public health issue. And it's much more effectively dealt with that way. And more cost effectively too, by the way.
Yeah. Martha, you want to ask your question?
Okay, I know you had a long discussion about felony murder, but I was just wondering, there's a lot of, like you said, there's movements to abolish it altogether. But would you be in favor of it being changed from a proximate cause theory to an agency theory, which would require some intent on the defendant's side to either kill or knowledge that he knew that death was possible?
I think that's sort of an end around of abolishing it, really, because then you're basically at the statute for murder as it stands right now. So it would you'd have to kind of ignore our common law theory of accountability to make that happen. I mean, I can understand why somebody would suggest that, but I guess my response would be, if you're going to go that far, you might as well abolish it, because that's essentially what you're doing when you do that.
I just know some states are based on that, on the agency. Yeah. Linda?
Are prosecutors subject to any oversight? Are there abuses of prosecutorial power?
Yes. So, prosecutorial misconduct is a pretty broad term, and that's used in appellate court cases a lot. One of the issues I have with that is prosecutorial misconduct is so broad, and it's anything from intentional unethical conduct to making an improper closing argument that could be labeled as misconduct. But certainly, as I said, with regard to police licensure, kind of the model for that program is the ARDC, and all prosecutors are subject to discipline through the ARDC. So they're subject to discipline by their employer, but then independent of that, they're also subject to discipline by the ARDC for unethical conduct, just like any other attorney would be.
And somebody would like you to define the term restorative justice.
So it's this whole concept of balanced and restorative justice, and what you're trying to do is repair the harm that any particular conduct caused on a community, get to the bottom line of what caused that behavior in the first place. And you're looking at not only just restoring society, but restoring the victim and the offender as well. So it's kind of all encompassing. It's not just, it's not retribution, it's not punishment. It's kind of going back to that whole best interest and standard that we use in the juvenile justice system. But again, these concepts can be employed in adult court as well. But it's looking at what happened, what caused the conduct, and certainly, as I said, you have a victim that's been impacted, and how we can make that person whole. But again, looking at society as a whole and the offender as well, and how that person can be restored.
Thank you.
Do abuses of prosecutorial power have criminal consequences? And do you favor expanded standards of prosecutorial performance?
Yes, they can, so depending on the type of conduct. So prosecutors are bound by the criminal statutes just like anybody else. So if a prosecutor, steals a candy bar from a grocery store, or is DUI or possessing drugs, or gets into a fight or whatever, they are subject to criminal statutes. There's no criminal statutes that apply just to prosecutors, but so perjury, for example, if somebody lies in court under oath, they're committing the offense of perjury. If a prosecutor lies in court under oath, they are also committing the offense of perjury. So that would be the example of misconduct that could also, certainly that's unethical and is going to result in the person getting fired and probably losing their license. But it's also subject to criminal prosecution as well, because that would be a situation where misconduct would be also criminal.
Okay. What about, do you favor expanded standards of prosecutorial performance? Or I don't know what that would be, but.
I'm not sure. Yeah, I'm not sure I understand. I mean, I certainly think prosecutors should be held to a higher standard. And if that's the question, in terms of, their accountability or what's expected of them, I have no objection to prosecutors being held to a higher standard. They should be. Prosecutors are there to enforce the law, and they need to certainly be held accountable if they violate the law or violate any of those standards. So if that's the question, as I understand it, I would not be opposed to that at all.
Okay, anybody else have any questions? Guess not.
Okay, well, I'm going to put the slide up while you think, Mike, Linda, and then we'll count down after you're done and stop the recording. And then if people want to hang out for a few minutes after the recording has stopped, I'll put your voices back on. So let me do this. Go ahead.
Okay. So thank you very much, Mike. That was a lot of material to cover. And at least you only had to do a few questions. So we're going nuts with all these questions from the state. So
I think you said 60 pages. Wow.
yeah, it was 60 pages.
Yeah, that's a lot. There's so much just here, but
yes. But thank you very much for being with us and taking all the time. We really appreciate it.
And
it was very helpful and informative.
Absolutely. All right. Thank you so much. I'm going to stop the recording in 3, 2, 1.